Hi everyone. My name is Shazia Khan. Today's unit that we'll be doing is managing employment relations and employment law. And the learning outcome we'll be doing today is learning outcome 3, which is to understand aspects of employment protection given to different types of workforce. But before we go into learning outcome 3, I just want to give you a brief outline of what we did in the last learning outcome, which was the learning outcome 2. In learning outcome 2, we looked at understanding recruitment and selection legislations in a country. We looked at who an employee is in accordance to the Employment Rights Act 1996. We then went on to look at the element of discrimination within the Race Relations Act 1976, together with the Sex Discrimination Act 1975, and how an action can be brought against discrimination if it falls within the race, sex, marital status, or ethnicity. We then went on to look at discrimination on the grounds of sex and how it applies to both men and women, and treating a woman unfavourably on the basis of a pregnancy, which is regarded as sex discrimination. We also went on to look at remedies to discrimination under the Declaration of Rights Party, Section 65 1B of the Sexual Discrimination Act 1975. We looked at unfair dismissal, and we looked at the case of W. Davies and Sons Limited and Atkins, where an employee was dismissed because he refused to act in accordance with the employee's wishes. We looked at the recruitment process with reference to the different stages. So stage 1, define the requirements. Stage 2, attract potential employees. Stage 3, select right people. And then we looked at stage 1, which applies to the job description and job specification. Then stage 2, which looks at the job advertising. Stage 2, which looks at job interview and the ability test. We looked at the selection process with reference to the initial screening, the completed application form, employment test, the comprehensive interview, the background examination, physical, or if there's any need for physical or medical examination, and permanent job offer. We then went on to look at why does HR need to follow legislation for recruitment and selection process and its importance with reference to National Audit Office, and looked at the elements of the importance of the average cost per recruitment. We then went on to look at discrimination and looked at the Sex Discrimination Act 1975, the Race Relations Act 1976, Disability Discriminations Act, and the Equal Pay Act. We then went on to what the Sex Discrimination Act prohibits, things like discrimination on the grounds of sex, marital status, and the fact that someone has undergone or is intended to undergo gender reassignment. We then went on to look at sexual harassment. We went on to look at the principles of discrimination legislation in relation to recruitment. So types of discrimination, types of sexual discrimination, direct discrimination, indirect discrimination. We then went on to look at victimization, positive discrimination, and remedies, and the principles of legislation. We looked at the element of the role of contracts in employment law, and looked at the importance of that within Employment Rights Act 1996. We then went on to look within learning outcome 2, what is a contract of employment, implied terms, express terms. We also looked at the UK's position on employment law and contract law, types of contracts. So you've got different types of contract. We looked at employee, worker, self-employed. We looked at terms and conditions of employment. And we also looked at varying an employment contract and the elements of that within a contract agreement. We also looked at how employees who wish to alter existing contractual terms have 3 main options. The legal remedies we looked at in employment contracts, such as reinstatement, re-engagement and compensation. We then went on to look at analysing the mechanism for establishing contracts of employment, and we looked at the contract of employment in regards to what it should have in, things like probationary period, notice period, benefits, looked at express terms as well, implied terms, varying terms, and this was in reference to learning outcome 2. Now we're going to go on to look at learning outcome 3 and elements of learning outcome 3. The importance of that in regards to understanding aspects of employment protection given to different types of workforce. So firstly, a background into employment law, because it's really important to identify what employment law is in regards to elements of it. So, you know, it's important to identify the elements in regards to the need for legislation as well within employment law. So the main thing about UK employment law is that it provides a framework and is one of the world's finest legal frameworks for defence of workers' rights. Naturally, employment law offers safeguards for employers, enabling them to dismiss rogue employees when the circumstances demand it. But in the main, the UK employment law helps to ensure the whole point of its fairness for all. So, you know, it's there to protect both the employer and the employee, and you know, provide any sort of support for them in regards to the legislation that needs to be implemented for workers in regards to their protection. You know, what the main laws are around employment law, why there's a need for it, you know, things like there's a need for it, which covers a wide range of areas such as disability, discrimination, it could be dismissal, grievances, holiday entitlement. So employment law covers a wide area of things and is really important in regards to the UK businesses. So background, we've got the employment protection legislation, which includes all types of employment protection. Legislation, to just identify to anyone that doesn't know what it is laws that are put in place by government to protect businesses and employees and consumers. And employment law involves keeping the employees safe and ensuring that employers are fair in any sort of conditions that they place. For example, you know, things like working conditions. It could be the fact that, you know, someone is, you know, in regards to their discrimination against their sex or gender. And it's a piece of legislation that covers a wide range of things in recruitment, pay, working conditions. So it could be a wide range of elements that it covers. The employment protection refers to regulations concerning employing someone and dismissing someone, redundancy procedures, mandated periods and severance payments, special requirements. And the employment laws in the UK are things like the Employment Rights Act 1996. It could be the Employment Relations Act 1999, maternity and parental leave. So, you know, the protection is there for all workers. And it is covered and protected by the Employment Rights Act 1996. It could be health and safety of the workers, how they carry out health and safety regulations, how health and safety is put in place, why employers need to be protective. And this legislation is there to protect individuals. And you've got the Employment Protection Legislation Index, which is indexed by the OECD. And the OECD indicators of employment protections are synthetic indicators of the strictness of regulation on dismissals and the use of temporary contracts. Employed people are those within the OECD definition, are those aged 15 or over who report that they have worked in gainful employment for at least 1 hour in the previous week, or who had a job but were absent from work during the reference week. The whole point of this employment protection legislation index is designed to show the costs to employers and protection offered by employees by the employment protection legislation. And the one of the frequent used measures is the strictness, as we mentioned, which this index calculated along 18 basic items, which can be classified in 3 main areas. So employment protection of regular workers against individual dismissal, specific requirements for collective dismissals, and regulation of temporary forms of employment. So these were the 3 main areas. Also, the 18 first-digit inputs are then expressed in either of the following. So the summary measure for collective dismissal is attributed just 40% of weight assigned to regular and temporary contracts. The rationale for this is that the collective dismissals indicator only reflects additional employment protection triggered by collective nature of the dismissal. In most countries, these additional requirements are quite modest. Moreover, summary measures for collective dismissals are only available since the late 1990s. An alternative overall index, so-called version 1, has been thus calculated as an unweighted average of summary measures for regular and temporary workers only, while more the last step of procedure involves computing for each country an overall summary indicator based on 3 sub-components: strictness of regulation for regular contracts, temporary contracts, and collective dismissal, as mentioned earlier. So this diagram identifies summary indicators for the strictness of employment protection, and it looks at country by country and also looks at the regular employment from the 1980s up to 2003, and then temporary employment from late 1980s up to 2003, looked at collective dismissals and overall EPL as well in regards to 1990s to 2003 for all countries, for most of the countries. So we're looking at 3.1 now, is to look at analysing the legislative and procedural protection that exists for workers. All the workers are protected under the Employment Rights Act 1996 as amended against suffering any harm because of any reasonable actions they take on health and safety grounds. The employment law regulates the relationship between employees and employers. As we stated earlier, it governs the employers expect from their employees and what the employers expect from their employers. So arbitration isn't, the use of arbitration is really important in regards to settling any sort of dispute. So, you know, they have mediation, negotiations, any sort of reconciliation. The whole point of arbitration is the fact that they are there to solve any sort of dispute. So arbitration is when a third party makes a decision on a dispute to resolve it. Arbitration is delivered by a neutral person who's referred to as an arbitrator. The arbitrator is impartial. This means they do not take sides. The arbitrator considers the arguments from both sides of the dispute at a meeting, hearing. They can make decision based on evidence provided. So, there's someone who's there, who's a peacemaker, trying to make sure that everything is resolved within the situation that's going on. So someone who is able to be a peacemaker and try to independent and who's partial, and who will try to resolve the disputes between the individuals. It's an alternative way to a court of law or tribunal. It's non-legalistic process with no swearing of oaths. Arbitrations are conducted in private rather than in public. The arbitrator will consider the written and oral submissions and at the submissions of the parties that are hearing. Questions are asked by the arbitrator to clarify certain points. There's cross-examination, and the arbitrator then makes the decision where appropriate, and award is then agreed and accepted. And this is really important because it's often used in collective employment related disputes. For example, a trade union might be in a dispute with an employee over a pay rise. The union would agree with the employee to ask the agency to appoint an arbitrator to hear each side's case and then make an independent and impartial decision. Arbitration can be used also for settling disputes. For example, if an individual and an employer might decide to go to arbitration to avoid the stress and expense of employment tribunal. However, with any workplace dispute, it's important to make use of internal procedures to resolve the issue in question before proceeding to arbitration. So, as arbitration is voluntary, but it's a way of trying to resolve disputes. Trade unions are really important in regards to trying to identify, whether it's a group of employees who join together to maintain and improve their conditions of employment. The typical activities of trade unions include providing assistance and services to their members, collectively bargaining for better pay and conditions for all workers, and working to improve the quality of public services, political campaigning and industrial action. What trade unions do? Nearly 7 million people in the UK belong to a trade union, and including nurses, school meal staff, cleaners, professional football. Most unions are independent of employers but have close relationships with them. So trade unions are there to try to improve better conditions for the what's it called, the elements of trying to improve working conditions, what they do in regards to UK, trying to help individuals, and it's really important to try to join in a trade union when you do get a job. Trade unions are there to, negotiate agreements with employers on pay conditions, discuss major changes to the workplace, such as large-scale redundancies, discuss member concerns with employers, accompany members in disciplinary and grievance meetings, provide members with legal and financial advice, provide education facilities and certain consumer benefits such as discounted insurance. Some workers join a trade union because they believe a trade union could negotiate better deals for them, provide better training for them, provide better working conditions, and give them more advice. How trade union works. Most trade unions are structured as a network of local branches with every workplace. Union net reps, as we mentioned, negotiate agreements with employees on pay conditions, financial situations. They're there to help employers in regards to negotiating better pay, providing new training for new skills. And, you know, the law gives you the right to join a trade union wherever you work. So this right applies whether a union has been recognised or not. You're protected from being disadvantaged for being a union member. Specifically, trade union membership is unlawful reason for refusing your employment, dismissing you, and selecting for redundancies. Trade union activities, when so, there could be things like voting in ballots on industrial actions, voting in union elections, and meeting to discuss urgent matters or any sort of annual conferencing. So there's a need for having trade unions and being part of a trade union because it gives you protection. Employment tribunals. So the employment tribunals are the judicial body with responsibility for workplace justice, being the main forum for deciding disputes between workers and employers. They are part of the wider judicial system and one of the three largest tribunals in the greater tribunals system. The previously called the Industrial Tribunals, employment tribunals were established in 1964. Initially, they decided appeals against training levi assessments imposed on employers by industrial training boards. They still hear some appeals against administrative decisions in respect of matters like the minimum wage or health and safety notices, but they've changed beyond recognition over the last 60 years. There are two separate jurisdictions for employment tribunals in Great Britain, one for England and one for Wales, and one for Scotland. Each is led by a senior judge who has statutory title of president, and each has its own independent judiciary. They have shared rules and procedures known as employment tribunal rules of procedure, and they sometimes issue joint directions and guidance which are found on their websites. The cases for which employment tribunals are best known include things like unfair dismissal cases and redundancy claims, claims about unpaid wages or unpaid pay claims of unlawful discrimination, and claims of detrimental treatment following protected disclosures. Most of their caseload consists of claims for compensation or other remedies made by workers against their employers. The ability of employment tribunals to decide cases and to award compensation or other remedies set out in the legislation is passed by Parliament. Cases are not arbitrarily decided, but according to the law. The most important items of legislation, like we mentioned before, is the Employment Tribunals Act and the Employment Rights Act and the Equality Act 2010, but there are other statutes as well that deal with them. Employment tribunals are not the same as courts, although they share some common features. Claims are brought and defended by people with professional legal representation, with lay representation, or with no representation at all. People are free to represent themselves if they wish, and they can be accompanied if they wished. The rules of procedure used by employment tribunals are less formal than the rules followed in the courts and are designed to give flexibility in ensuring that each case is determined fairly and justly. So common law courts, an employee who wishes to bring a contractual claim may elect to pursue it at High Court or the County Court instead of the Employment Tribunal. In general, a claim may be brought in the High Court if value is more than 15,000. The process of the High Court and County Court tends to be more formal and lengthy, as we mentioned earlier in the slide about the Employment Tribunal, where it's a little bit more informal. So arbitration, as we mentioned, is when a third party makes a decision in regards to a dispute, and it's up to the arbitrator to decide in regards to dispute resolution. The arbitration scheme is a voluntary scheme which was set up on which came into force in May 21st, 2020, is intended to provide a more faster, non-legalistic and cost-effective alternative to employment tribunals. Since the scheme has never been widely used, and apart from a brief spike in 2011, usage has fallen in the recent years of how many cases have been dealt with. Although ACAS are not aware and not averse of reinvigorating the scheme, the members of panel of independent arbitrators, in anticipation of revival, there seems to be little appetite within this and in regards to trade unions. The scheme actually only covers unfair dismissal claims and expressly not intended for cases involving jurisdictional or complex legal issues, or ones which give rise raise points of EU law. It is ideally suited for claims which are quite straightforward, simple, and are sensitive, involving issues which both parties may prefer not to air in the public arena of an employment tribunal. Although the scheme will cover cases of alleged constructive dismissal, it will only do so where the parties agree that the events would take place or to amounted to dismissal. The scheme does not cover claims for breach of contract. So the diagram there is equality and discrimination and looks at the basic laws around it. So this is a good article to read in regards to discrimination. Is www.thebalancecareers.com, types of employment discrimination with examples. It's illegal to discriminate anyone against on the basis of the protected characteristics, which are age, disability, gender reassignment, maternity, pregnancy, religion, sex, unfair treatment. While all forms of unfair treatment are bad at work, you should address them. The ones that break the law are especially sensitive ones, as we've just mentioned. Bullying is behaviour from a person or groups that are unwanted and makes the employer feel uncomfortable. And the protected characteristics under the Equality Acts, as I've just mentioned, this may affect your finances because employment tribunal affects your reputation. So, you need to bear in mind that, there are different consequences of unfair dismissal and unfair treatment at the work. So employers need to take into account the different breaches and things like that in regards to treating people unfairly. Examples of unfair treatment of employee. So unfair treatment at work can be a devastating impact on employees. It can cause them to lose motivation, feel unappreciated, and it can lead to legal action. As an employee, it's their responsibility to make sure that your employees are treated fairly and with respect. By taking steps to prevent unfair treatment, they can create a happy and productive work environment, reduce employee turnover, and improve productivity levels and the overall success of the business. Unfair treatment at work can take different forms. As we mentioned, it could be discrimination, it could be harassment, bullying, unfair promotion. Unfair treatment, while it's not acceptable for anyone to be treated unfairly at work, it even gets worse when you break the law. This is why it's important to have rules in place to prevent this kind of thing and deal with it straight away because you need to comply with the UK employment law. The Equality Act 2010, as we mentioned, has protected characteristics on the basis of age, disability, gender reassignment, marriage and civil partnership, maternity and pregnancy, race, religion or belief, sex and sexual orientation. As an employer, it is imperative to recognise and respect these characteristics and create a workplace that thrives on diversity and inclusion, and failure to do so only damages the morals of the affected individuals, but opens the door to legal repercussions, including things like, people will go to employment tribunal. So each business and organizations need to adhere to the employment law, and it's not negotiable. So it's really important for any organization to apply the law and be familiar with what happens if you breach the law, because there's elements of it that, if you breach the law, you will be going to into a tribunal. So it's really important that you as an individual recognize situations where people are being treated unfairly. So examine 3.2, examine the legal consequences of unfair treatment of an employee for the employer. So, recognizing that this is really important. Unfair treatment can rear in its head in various scenarios. The overall well-being of an employee, it's important that you recognize where unfair treatment at work is happening. And, there's some scenarios here. Example, you're 19 weeks pregnant. A couple of weeks ago, you applied for a job at a big department store. After a successful interview, received a job offer, but when you mentioned you were pregnant, the offer was immediately withdrawn. If this is because of your pregnancy, it's lawful pregnancy discrimination. Another example is you want to apply for a job, for the employer says you have to fill in your application form line. This is difficult for you as you have learning difficulties and would prefer another more accessible format. You ask the employer if they can submit a paper application, but they refuse. This is unlawful disability discrimination. This is if you're an employee or a worker. Just 1 minute. So example, you have a mental health condition and your employer is threatening to dismiss you because of your sickness-related absence. This is unlawful disability discrimination. Another example is you've just returned from maternity leave. Your employer has passed some of your responsibilities to a colleague and you've now been told that your hours will be reduced. This is likely to be pregnancy and maternity discrimination. Your employer is discriminating against you by changing your working conditions because you were on maternity leave. Bullying. So if an employer behaves in a way which causes you to distress or offends or intimidates you, this could be unlawful behavior under the Equality Act. This is called harassment. An example of this is you're being bullied at work by several of your colleagues because of your sexual orientation. They make hurtful comments about your sexuality and offensive gestures. You've told your manager, but he's dismissed as it's banter and has been nothing about it. Since reporting the harassment, the bullying has got worse and you're not now off sick from work because of the stress. This is harassment because of your sexual orientation and it's unlawful, and you can take action against the employer under employment under the Equality Act. So some other forms of unfair treatment is things like, age discrimination. So a company chooses to hire younger and cheaper workers while sidelining experienced older workers for key positions. The impact of this is older workers feel undervalued and may bring forward claims of age discrimination, leading to potential legal consequences for the company. Another one is discrimination based on personal relationships. So management singles out employees based on their personal relationships or friendships within the company, providing benefits or promotions to those with close ties while ignoring merit-based considerations. And the impact is that it fosters a toxic working environment where favoritism exists over those who truly deserve it, causing feelings of alienation and distrust among the workforce. Another popular example is dress code, enforcement of policies. So company policies such as dress code or punctuality are selectively enforced, with some employees facing repercussions while others, often favoured by management, are exempt to this. The impacts of this is that it erodes that kind of trust of fairness in the workplace, creating a perception of bias and inconsistent application of rules. So now we're going to go on to 3.3, and that looks at applying law relating to the nature of protection for workers to a given situation. So general unfairness is not a legal claim just because treatment is unfair. It does not mean breaking any employment laws. However, unjustly someone feels that they've been treated. However, there are a variety of claims that they can make. You know, if someone's been treated unfairly, you know, they need to make sure that people are treated fairly. So protection, oil employers are protected, as we mentioned earlier, by the protection under the Employment Rights Act as amended. So termination of employment is an element of the employment, and this means where an employee or employer can decide to end, which is to terminate an employment contract. This may be done by an employee resigning or an employee dismissing an employee. The employer must normally give you at least notice outlined in your contract of employment or the statutory minimum notice period, whichever is longer. Summary dismissal is dismissal without notice and is only allowed for gross misconduct. The employment contract is being terminated because of employee's decision to resign, they have to provide the required amount of notice, which should be stated in the contracts. Depending on the circumstances, you know, there's different ways of dismissing. So the principal case that may arise on termination of contract are wrongful dismissal, unfair dismissal, a claim for redundancy payment, a claim arising out of failure to give written reasons for dismissal, or a claim for discrimination on the grounds of sex, race, disability, sexual orientation, religion, or belief. So wrongful dismissal. Wrongful dismissal is a situation that arises from a breach of employment contract by an employer when dismissing employees. Common examples of wrongful dismissal are no notice or inadequate notice is given, and it's not a case of gross misconduct entitling the employer to dismiss without notice. An employer has, an example is an employer has dismissed the employee on the spot but failed to provide them with statutory contractual pay in lieu of notice. Wrongful dismissal is a specific type of claim where an employee is alleging their employer has breached contractual terms when terminating their employment. Wrongful dismissal is a legal concept that describes the unlawful termination of employment by reason of breach or breaches of the terms of the contract. In context of a wrongful dismissal claim, this could be based on either an implied or express term. One of the most common examples of wrongful dismissal is breach of an implied term to provide the employee with the minimum statutory notice. In contrast, breach of an express term could be where the employer has failed to provide the employee with the minimum contractual notice period as set out in the contract of employment. In cases where the employee's contract make provision for enhanced rights, they have entitled the period of notice rather than statutory minimum. Wrongful dismissal can occur in a number of different ways, including dismissing an employee on the spot, as we mentioned earlier, without letting that individual work out their full contractual notice, or alternatively dismissing an employment without paying them in lieu of notice. When it comes to breach of right to notice, much will depend on whether or not the contract makes provision for in lieu. In either scenario, unless employees found guilty of gross misconduct, where they may be summarily dismissed without notice or pay in lieu, the employer must honour the employee's right to notice or notice pay. So defences, so the references to the UK employment guide, which you can look at. Defences, so an employee nature of the claim. So an employee will be able to bring a claim for breach of contract. The employer terminates the employment without giving the appropriate period of notice, as we just mentioned. Defences, the only defence available to the employer are either that proper notice of termination, payment in lieu has been given, B, that the employer is entitled to dismiss the employee without any notice. The circumstances in which employee is entitled to terminate without giving notice sometimes sets out the contract of employment. If the employer will show the employer's behaviour amounted to fundamental breach of their obligations under the contract. Compensation, so if an employee is successful in wrongful claim, they'll be entitled to compensation. The next one, damages for failure to follow disciplinary procedure. So in unfair dismissal claims, employment tribunals take their ACAS code of practice on disciplinary and grievance procedures into account where relevant, and may increase an employee's compensation award for up to 25% where an employer unreasonably fails to follow the code. If the employer, as we mentioned, has laid down a disciplinary procedure that forms part of the contract, then you could sue for breach of employment contract if they haven't followed it. Policy negligence leaves the business at risk for financial losses, security breaches, and a ruined reputation. So it's really important that you follow the procedures that are put in place. If you fail to follow, the next one is damages for failure to follow the statutory dismissal and disciplinary procedure, SDTP. If you fail to follow the appropriate statutory dismissal and disciplinary procedure, and the employee subsequently brings a claim before an employment tribunal and it's successful, their compensation can be increased up to 50%. So you need to really make sure that you are following the procedure, because if you're not following the procedure, then the dismissal automatically, Section 98 A of Employment Act 19 states that a dismissal is automatically unfair if the STDP applies. So you need to make sure, and has not been complied with, employers need to make sure that they are complying with everything, because it would increase the award to 50%. And the famous case for that is the case of ATHE, Edinburgh Limited and Kennedy, where the employer had notified that she was at risk of redundancy. She had asked for a meeting with the manager and a representative of the HR department, at which a number of matters were discussed. The next day, she was notified by letter that her redundancy would take effect in 4 months' time. The letter made no mention of her having a right of appeal. At some point thereafter, she did, in fact, have a further meeting with HR department representative. The employment tribunal concluded that the dismissal was automatically unfair because the claimant had no right of appeal, and the affording of right of appeal was part of the statutory dismissal procedure. She was then awarded compensation with then a 40% uplift. So it's really, really important that the statutory dismissal and disciplinary procedures are taken into account in regards to dismissal cases. Garden leave. Garden leave is the practice of whereby an employee leaving a job, having resigned otherwise that had employment terminated, is instructed to stay away from work during the notice period while remaining on the payroll. Sometimes the primary reason for giving garden leaves is to safeguard against possible detrimental actions or behaviour that the employee might indulge in during their notice period. So it's really important that, when it comes to garden leave, is taken, and it's an alternative way of dismissing an employee. The term garden leave is made its way into the dictionary in mid-1980s and started to be used by the public after there was an episode of Yes, Prime Minister, and in that it referred to as garden leave. Garden leave in the UK is a far different term than in the United States, which commonly uses term administrative leave. Some suggest that it's given the name since people can't work for their old employer or their new one during this time. The garden leave clause in the employment contracts is most often used when an employee leaves to go and work for a competitor. This effectively provides a buffer zone between their current job and their future one. Essentially, this prevents them from learning any confidential business information so as not to share it with the competitor. Putting an employee on gardening leave also helps someone taking on their previous role to do so without interference. When on leave, employees are also excluded from receiving future-looking information that could potentially be valuable to another company, such as future business strategies. Unfair dismissal. So, as we mentioned, unfair dismissal previously, it's if you were sacked for discriminatory reason, you can make a claim for discrimination. If you've been employed by the company for 2 years, you can make a claim for unfair dismissal at the same time. So, you need to, make sure that you know your rights in regards to unfair dismissal because, people, organizations can dismiss people unfairly. And it could be entitlement to claim, it could be elements of constructive dismissal, or potentially fair reasons. So constructive dismissal is where an employer has done something that seriously breaches your contract. You might be able to resign and make a claim to an employment tribunal, and this is constructive dismissal. Potentially fair reasons for dismissal. So it could be misconduct, it could be poor performance, ill health, redundancy, because it would be illegal to continue to employ the individual in this current capacity. So, for example, if a driver is disqualified from driving and his job is a driver, then they can dismiss you on that basis, and they will in the fact that the job is that they're not capable of doing it. And some other reasons as well could be things like it could be expiry of fixed term contract or dismissing temporary workers. When a client refuses to work with an employee, there's no other work for the employee to undertake. If there's personality clash as well, sometimes that's an element of it. And if there's significant conflict of interest, a senior partner has a partner who works for a competitor and is a serious threat. Retirement is another one, but the default retirement age is abolished. So as a result, age can no longer be a reason for dismissal. So, it's important to, take into account there's different reasons for unfair dismissal and potential fair reasons for dismissal as well. The next element is whistleblowing, and this in employment law is a law that is located in the Employment Rights Act 1996, and it provides the right for a worker to take the case to an employment tribunal if they've been victimized at work or they lost their job because they have blown the whistle. The definition of a whistleblower, if you're a whistleblower, if you're a worker and you report certain types of wrongdoing, this will usually be something you've done at work, though not always. The wrongdoer you disclose must be in the public interest. This means it must affect others, for example, the general public. As a whistleblower, you're protected by the law. You should not be treated unfairly or lose your job because you've blown the whistle. You could raise your concern at any time about an incident that happened in the past, and is happening now at work, or believe it will happen in the future. You're protected if you're a worker, for example, if you're an employee. You can take your case to an employment tribunal if you've been treated unfairly because you've blown the whistle. So, they are, it is something that you could go to the employment tribunal for because it's unfairness. And it's within the UK, within employment law, whistleblowing has become increasingly important part of employment law landscape, particularly in areas such as finance. This is in part due to the fact that there's increased emphasis on encouraging whistleblowing claims and is part of the fact that compensation for whistleblowing claims is unlimited. In the UK, workers can disclose certain information and obtain protection in relation to that disclosure. It's not the case that a worker may make a disclosure and claim protection. The disclosure must relate to one of the subject matters defined as qualifying disclosure. In addition, the worker must follow a set of procedure when making a disclosure. In general terms, most qualifying disclosures made to a worker's employer will be protected. Stricter regimes are set out in disclosure is made to someone other than their employer. The intention of the law is to encourage workers to disclose their concerns within the organisations where they are employed and to avoid reckless and irresponsible disclosure. Therefore, unless the matter is exceptionally serious, the employer or an appropriate prescribed person will usually be informed of the matter before it's disclosed more widely, and the worker must act reasonably in making the wider disclosure. So what disclosures are covered in regards to this? So in order to attract the protection of statute, the disclosure must be a qualifying disclosure, as I mentioned earlier. This means that any disclosure of information which in the reasonable belief of the worker making the disclosure is in the public interest and tends to show one or more of the following. So a criminal offence it might be, failure to comply with legal obligation, could be a miscarriage of justice, could be the health and safety of an individual that has been endangered, damage to the environment, or concealment of information showing any of the above. So, when it comes to areas of whistleblowing, managers should be trained to ensure that managers to whom disclosures are made are protected under the right. So whistleblowers do have the protection now able to go to employment tribunals. So we finished learning outcome 3 now on the element of the managing employment relations, employment law, which is to understand aspects of employment protection with different types of workforce. So we've looked at different types of employment protection legislation, unfair dismissal, legislation around that, arbitration, trade unions, and we've looked at employment tribunals, common law courts. We've looked at ACAS, arbitration scheme, the legal consequences, and given you examples of unfair treatment as well. We've also looked at wrongful dismissal, and we've looked at defences and garden leaves and unfair dismissal. So we've looked at a huge amount of legislation around employment law. These are the references we've used for today's session, which you can refer to, and the links are there also for internet sites. Please also refer to ebooks on Moodle and any sort of additional reading on Moodle for this, for learning outcome 3, and make sure that you are referring to Moodle for any sort of additional reading, and any sort of questions you've got, please email learnerwork@ukvarsity.co.uk. Now we've finished learning outcome 3. The next session we'll be doing is learning outcome 4. So thank you for attending today's session, and I will see you in learning outcome 4. Thank you.